This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Joviat. Tonight we're taking your calls and questions about federal employment law. Alabama has got around 40,000 federal civilian employees, and half of those are working right here in the Tennessee Valley, which makes this wave of layoffs and firings from the Trump administration felt so much more here than in most other parts of the country. So what if you think your federal job may be gone in the near future? What should you be doing to prepare? What action should you take if you get that notice that says you're being fired? Tonight's guest is a local attorney that, like many of you, has served in the military and had a government job before working in private practice. So if you're concerned about your rights and how to navigate what's being coldly referred to as a reduction in force, a RIF, we want to hear from you. Call in the 31 Law Call number 256-536-0077. You can call in and be live on the air, or you can text us to that same number and we'll be getting your text as well. You can also email your questions. You can email any day of the week on any legal topic. You send it to lawcall@waytv.com. And when we get to a show that's on point, we pull some out, and we've got some of your questions about federal employment law. So getting us started tonight, Michael Timberlake's here from Timberlake, League & Brooks. We're skipping over our video that we normally do, our You Make the Law Call video, because this is a pretty complicated topic and a lot to cover.
Yeah, I mean, we clearly live in strange times at this point in time. Now, I think there's so much chaos and there's so much unknown going on in terms of the way that this is being dealt out, you know, by social media or by email or by somebody that we don't know who is. And so we've got my good friend Tony Mastando here to help us out. Tony's has served in the Army. He's been a government employee, and he and his wife and our good friend Eric practice employment law here in North Alabama for at least 20 years, right?
It's been a while, and you know, there's really a lot of government employees here, a lot of military here, so I'm glad that I can sort of touch on those parts of my past and offer a little bit of legal advice to folks who are facing some uncertain times.
Yeah, how much are you hearing right now? Are you hearing people worried? Are you hearing actual job loss, or both?
So I'm starting first I was hearing more people being worried, especially, you know, there was the suggestion that you take a fork in the road. Yeah. I got a lot of calls about that, and what should we do about that? Should I take that? Should I not? And that sort of deadline has come and passed. So as a result of that, I started getting more calls about people who are concerned about, you know, if I'm let go, for, you know, either this reduction in forces or if I'm terminated for cause, you know, what can I do to start, you know, getting ready for that?
It's interesting.
Yeah, so you know, we've got you know, all kinds of different situations here where government employees are either being terminated or you know, they're getting poor performance reviews for things that, you know, they were never reviewed for, things like that. You know, what do you make of the kind of the chaotic nature of this whole situation?
So, I mean, really, they're taking it one day at a time. You know, they're kind of rolling with the punches. They're trying to get ready. You know, a little bit of paranoia goes a long way in getting prepared. You know, they don't know from which direction their next piece of information doesn't come. Lots of their agencies are changing their heads. So, you know, the administration is changing quickly, and they're having to figure out whether or not their particular government, their section, is going to continue doing the mission that it has, or is it going to shift to something else? So there's really so many people out there that just are taking it, you know, one day at a time.
So if you're suspecting that you might, if you're suspicious, what are you telling people to do to get ready?
So the first thing I want you guys to do is to gather your documents. Get ready. Download your EOPFs, your official personnel files. Pull all your performance evaluations. Get your SF50s gathered up. And if you haven't been rated by your supervisor, say you've only been there a short term, in the meantime, ask your supervisor if you're on good terms with them, if they'll give you an interim performance evaluation, and have that tucked in your pocket. Because if you're looking down a decision to terminate your employment, and they're going to be saying, you know, your employment was terminated for poor performance, but if you have all these great awards, this stellar, you know, 5s on your ratings, you know, it kind of makes that look a little pretextual.
Yeah, and so what are the remedies that they could a federal employee could potentially have? Say, clearly, there are people that are going to be terminated wrongly under these circumstances because it's basically a sledgehammer in a dark room, and people that have not been had performance reviews are getting negative performance reviews. What are the remedies for federal workers under these situations?
Well, the remedies and your due process often depend on what your status is. Are you a competitive employee? Are you an exempt employee? Are you a probationary employee? Are you a temporary employee? So each of those sort of characterizations or classifications will say what sort of due process rights you have to object or appeal to your adverse employment action. So if you are part of a collective bargaining agreement, if you're a unionized employee, you'll have a different set of rights compared to the other employees. And you're going to want to make yourself familiar with if you have an employment letter, or if you have an offer letter, if you have an agency handbook. You're going to want to get all these things together because it's a bit of a puzzle, and your status can change as you are in your position longer. If you've been there 12 months, or you've been there 2 years, or you've been there 3 years, that's going to, the point at which you switch from a probationary to a permanent employee can vary wildly between agencies and things. So you really need to know your own employment status and do your kind of gathering your research and grabbing all the documents that relate to your employment that you can. And if you are given that notice, you're going to want to, if you're part of a union, consult with a union representative, your union steward, or if you're not subject to that, you might want to talk to a federal employment law lawyer and kind of understand kind of what those shifting sands are.
We got a caller that didn't want to go on the air, but got the letter that says send 5 things rather quickly, and their boss is saying, oh, hold off, don't do it until tomorrow. So do they send the 5 things, or do they not? Do they hold off? You're hearing this from a lot of places.
You see a lot of suggestions on the internet about what 5 things they should send. Most of them aren't things we could talk about here on the show because the language is kind of salty. But and I would encourage people not to do that. Right. But if you've gotten this email from some entity that we don't know what is, and then your boss, is that going to, what do you need to do?
I would suggest that you contact your supervisor and you listen to what your supervisor has to say. Okay. You have in your chain of command, you've got your supervisor, goes all the way up to the agency head. Some agency heads are giving guidance. Like, for instance, the FBI is giving guidance to theirs, and the Department of Defense is giving guidance to their people. So I would scan that. The deadline for doing that is Monday by midnight, I believe, 11:59. Okay. And so just kind of listen to what your supervisor has to say and do that. And if you do end up doing that, I would suggest making it kind of generic. I mean, as a former military intel analyst, I know operations security is really important. We don't really know if you're firing these things off to HR at OPM.gov. You don't know who's going to see it, who's getting it, right, or anything. And you're supposed to be copying your supervisor. So there's a lot of information. So I would be, reticent to provide that unless my supervisor says, go ahead and do that.
Okay.
So you could say, I handled classified information. I handled more classified information. I handled a lot of classified information. Yeah. Even more classified information. I wrote the response to this email.
Yeah. So we're also telling people, be realistic. Start getting your resume together. Okay. Look around for what other jobs there are. Pull all your certifications and things. Get your paperwork. Exchange personal contact information with your coworkers and your supervisor. They're going to be, if you find yourself in a position where you need some information, you need a recommendation, you need somebody to talk to, somebody else who's been through the war that you're going to go through. It's good to have that contact out there, because you might need to know, I forget what project we worked on, and you can talk to somebody else who's been there with you and kind of prepare those things.
And you won't be able to do that through the business email or cell phone that you were provided before, so get the private stuff.
Your .mils will probably be going away.
Yeah. Okay, you were talking a little bit about probationary status, and we got this text message. Remember, you can call in or you can text in with your questions. I've worked for 14 months for the USDA and still am considered a probationary employee. I got the letter that said I was being fired for performance reasons. I've always received good reviews and even got a promotion based on my work. So how can I challenge this email?
So, probationary employees have some of the fewest rights of all employees.
Okay.
But one thing they do have protection for, one of the things that is if a RIF has happened, a reduction in forces, and they're not provided their due process related to the RIF. The RIFs come with certain requirements. You have to notify people when it's effective. You have to tell people if they're eligible for other positions. You have to, there's certain requirements, notification requirements as part of a RIF. So one of the things you can challenge as a probation employee is the RIF status. But, they are linking this to poor performance. So is that pretextual? Can you go forward and dispute that with those things that we talked about? Your performance evaluations and all those things. So it does make for the poor performance would pull the probationary person out of their ability to fight. But if it's actually really a RIF, you have an opportunity to appeal that decision.
So, I mean, and what would be the ultimate, outcome in a situation like that? Say that if you were able to, appeal the decision and able to be favorable, I mean, are you going to have your job back? Are you going to get some severance? What kind of, options for remedies are there out there?
Yeah, that's a long way off, right?
And maybe a pipe dream.
Yeah, maybe a pipe dream, and it could be an expensive one too, to fight this throughout the whole process. If you are subject to a RIF, there are severance payments if you qualify for them. You had to have been working there for at least 12 months. You have to be a permanent employee. You have to be in good standing. You have, for each year you're eligible, each year of service, you're eligible for a week's worth of severance.
Yeah.
So up to a cap of 1 year's salary. So there is, as part of a RIF, there's the severance possibility. But if you're fired because of poor performance, that goes away.
Okay, they're telling us to take a break. We've got text and we've got other questions coming in. Stay with us. We'll be right back talking more about federal employment law.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back. Tonight we're talking about federal employment law and all the changes that are going on with threatened jobs and a reduction in force. We've got with us Michael Timberlake from Timberlake, League & Brooks. They're personal injury attorneys. And Tony Mastando, who is a federal employment law attorney, also has a background in the military and working for the federal government, and now seeing so many people with lots of questions and whether they're afraid of getting fired or they're getting those notices. We were talking before about people being expected to send in things, send in the five things about what they're doing. Someone had called in and said, how do I know that the Russians won't see my email if I send this in about that? You don't really know.
You don't. there's no such thing as secure communications over the internet if you're just sending emails to hr.opm. So yeah, you really
don't trust it.
And then,
yeah, I mean, it's clearly don't share anything confidential or anything that's classified information would be the #1 thing.
Alabama is a certain type of state as far as jobs. Ask this question in a way that makes sense. Somebody texted in a question.
Yeah, we're kind of talking about, Alabama we're a termination at will state. Basically, you can be fired for good reason, bad reason, or no reason. There's certain constitutionally protected, groups that are protected. You can't be, fired because of race, color, national origin, skin color, sex. But those typically are just, you can be fired without cause. They don't have to give you a reason. Other states have differing provisions or state laws that protect employees and say they have to be fired for cause. In this situation, is it going to matter that we're in Alabama and that we're a termination at will state, and that other states, maybe like California, have laws that are more favorable to employees?
So I guess I kind of hearken that to employees who are part of a union, right? They're subject to a collective bargaining agreement, and there's the government, the agency, is supposed to respect that. I mean, we're hearing, that may not be the case. So if the agency isn't following that, that's grounds for a lawsuit. So you have to, you have to abide by the contracts. Certain of the collective bargaining agreements, there's a lot of different kinds of them, but they have termination provisions. They have provisions that relate to disciplinary actions. And one of the things that, if you are subject to one of these collective bargaining agreements, you may have something called the Weingart right, and that allows you, if you're subject to a discipline, to ask that a union representative be present. If you're called into a meeting and you have a reasonable belief that they're going to be either disciplining you or potentially terminating your employment, you can say, I'm going to stop this discussion, and I'm going to wait until we get a union representative to come attend this with me. And if we have to put it off until there's a union rep available, then we have to do that. It doesn't change it, but it may sort of delay things a little bit to get that in order, and to make sure that your chain of command is abiding by the collective bargaining agreement to the extent that they're willing to do that.
So if somebody is in this situation and they hire a lawyer, what's going to happen? Are you taking it to court? Are you filing a lawsuit? What are the steps that you're able to take?
There's a lot of different forums, and a lot of it depends on your status as an employee and what the type of claims, what the reasons for this adverse action or the termination is. The main forum really is the MSPB, the Merit System Protection Board. There's also an EEO complaint.
Okay.
There's also the Office of Special Counsel.
Okay.
And then there's the grievance process.
Are these trials, or what are these?
So if you go to the MSPB and you are appealing an employment decision, you can end up in kind of a mini trial in front of an administrative judge.
Okay.
And as part of that process, you'll file your appeal. The judge will acknowledge having received it and send out an acknowledgement order, setting up what the issues are for discussion and things. And then the agency will give a position statement on what the reason is for terminating you or doing their adverse action. And then you'll enter into a discovery phase. You'll in your appeal process, you're going to you'll ask for a hearing, and you'll have a hearing where you'll be able to cross-examine witnesses, give direct testimony, submit evidence, and that goes before the administrative judge. And the administrative judge has a certain amount of time before they can generate what's called an initial decision.
Okay.
This initial decision is you will have some 30 days if you don't like it to appeal the appeal, appeal that, and you can appeal that to the full MSPB, the full board. And then the full board will review it and issue a final decision.
Do we think these administrative judges are going to be sympathetic, or are they going to be part of the Trump administration? They're going to be pushing that plan?
I think the nature of the leadership of the MSPB is subject to change, and I think the nature of the administrative judges is subject to change. The administration has indicated that it's trying to rework the top and rework the administrative judges as well. Okay. I think that the judges that are in there now, are ones that have a long history of serving in that capacity, and they're fine and upstanding stewards of the public trust.
As long as they stay there.
Right. But yeah, so we don't know what we're going to get, and we don't know. I mean, in this situation, you're getting, people are getting a random email saying that their jobs is over. You're not, you don't get to meet with your supervisor. You're not getting any feedback. You're not getting any information about why you're being terminated. You're just getting an email. So it's incredibly chaotic.
And the reasons for termination can also determine which path you're going to travel down. If you're a whistleblower as a federal employee, you can go to the Office of Special Counsel and launch your retaliation whistleblower over there, or you could choose the MSPB, or you can do both, but you have to do that in a sort of a staged approach. So it's good to talk to somebody who's kind of knows the ropes and can help guide you through that process, because it is confusing.
We got this text question. Someone writes in, I have over 30 years of federal service. If I get laid off or RIF notice the next day, will I still be eligible to apply for retirement from the federal service within the certain days after the layoff for that notice?
You should, if you've been a federal employee for more than 20 years and you're over 40 years old, I believe it is, you should be able to qualify for VERA, this voluntary early retirement. And alternatively, if you've been in 25 years as a federal employee and you can be any age, you can qualify for VERA. So I think under those circumstances, this gentleman sounds like
should be safe.
Yeah, should be able to ask for retirement, early retirement.
They're telling us to take a break. We'll take a break and be right back answering more of your questions about federal employment law. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Tony Mastando with Mastando and Artrup in Huntsville, 256-532-2222. Also check out MastandoArtrup.com. Here's how to get in touch with Michael Timberlake with Timberlake League and Brooks in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon does family law right here in the Tennessee Valley. Her 256-539-7337 or SharonFamilyLaw.com.
How does somebody pay for a federal employment lawyer? You have to pay for it?
My goodness, yeah. It's hourly, it's not contingency work, so there's an hourly fee for it. And you're protecting your livelihood. Yeah. You have to really weigh whether or not this is something that you think you're going to be successful at in the long term. None of these actions are really, sometimes if you go through a legal process, if you go through like a whistleblower retaliation process or something, at the end of that, you can get your fees covered by the defendant.
Gotcha.
Here, you can request fees, but they don't necessarily have to award them.
Yeah, but it's going to be worth it for you to consult with an attorney, at least to find out what your rights are.
Talk to somebody, yes. Have a great week.